When you are filing your 601A waiver, you need to avoid these mistakes so that you don't end up getting denied or unnecessarily delaying your case, even more so than USCIS already is. I am U.S. Immigration Attorney Lilian Chukwurah, and I help my clients get green cards and citizenships for themselves and their families using the U.S. immigration law system. The 601A waiver is for someone that is in the U.S. And has unlawful presence, all right? So if you have unlawful presence, but you have a U.S. citizen spouse, child, parent that's looking to file for you to get your green card, but you have that unlawful presence, you have to leave the U.S. because you entered without inspection. That's really the key with the 601A waiver, is that you entered without inspection. When that is the case and you have to leave the U.S., you want to make sure that you have a 601A waiver in order to be able to come back. Right? Watch my video from last week where I broke down what it is and all the requirements. Now, in this video, we're going to be talking about the top 3 mistakes that people make when they're doing their 601A waiver. The top mistake that people make is not showing the hardship. I see this all the time where people file the form, they send it off to USCIS and they think that is it. But you have to show the hardship, because that is what the 601A waiver is all about. Showing that your qualifying relative, that is your spouse or your parent that's a U.S. citizen or permanent resident, will suffer extreme hardship. That is the key. So remember also that the 601A waiver does not have an interview, right? USCIS is not going to interview you. There's not going to be a court case for your 601A waiver. So all USCIS has to go off of is paperwork, right? What documents did you send in with your application? Do they believe that that is enough to show the hardship, right? So that's really key here. So your evidence is top priority, all right? The form is basic, right? Filling out the form is just a formality. Your main concern when it comes to the 601A waiver is the evidence that you're including to show the hardship. And if you don't know what evidence to include, let's talk about it. So if there's any health issues with the qualifying relative or someone that the qualifying relative takes care of, you want to include those documentation, and you need to include those hardships in your statement, okay? So you want to include evidence of the hardship. This can be medical hardship, financial hardship, whatever the hardship is, you want to document it. Like I said, it's your paperwork that USCIS is going to base their decision off of. So typically you want to include a detailed statement. So this statement will say what the hardship is, right? You, as the non-immigrant, what is the hardship that your qualifying relative will have? What's the relationship between you and your qualifying relative? Things like that, right? You want to be as detailed as possible about how you are an essential part of your qualifying relative's life. What do you do for them that if you are not in the U.S. to do for them, that they will suffer this hardship, right? What is it that they must be in the U.S. for, and how do you assist in that? For the qualifying relative, you want to detail all your hardships, right? Whatever it is, like I said, medical, financial, whatever, you want to include those. And if the issues that, there's medical hardship, there's financial hardship, but there's also you're going to school, right? Your spouse is in school trying to get this degree. And if they went to your home country, they won't be able to do it. Or if you were to leave the U.S., they won't be able to afford it because you're the one paying for it. Those are all things that you can include. If there's children involved, right? If you and your spouse have children, and taking those children to your home country will cause a hardship for your spouse, you need to include that as well. What is the hardship that your spouse will now suffer by you not being in the US. So this can be, they used to work 8-hour shifts, but it's during the time that the kids are at school. So now they have to figure out how to work and take care of the kid all by themselves, right? So you really want to think through what is those hardships and include evidence for each of those things, right? If it's financial, you need to include some bills, right? Showing how you're paying the bills, bank statements, things like that. Medical, you need to include medical records, okay? So whatever it is, you want to include it. Make sure that it's detailed in your statement and also detailed by including documentation backing up the statement. The second mistake that people make is assuming that they qualified for the 601A waiver. Let me explain what I mean. If you do not disclose that you have had other immigration violations or that you have a criminal history or things like that, you may just go ahead and apply for the 601 waiver thinking that that is all you need, right? Because you entered without inspection, you read about the 601A waiver, you do your I-130, you get that approved, you go ahead and file the 601A waiver, but you don't disclose that you had other immigration issues. You don't disclose that there's been like misrepresentation. You may have had a fake passport in the past, whatever that may be. You did not disclose it, or you did not know that it can actually cause an issue later. So let me explain where this will apply. So let's say you've had a misrepresentation in the past. You applied for a US visa, included false information. The visa wasn't approved, and then you decided to enter without inspection. Yes, you can do a 601A waiver to waive the fact that you entered without inspection and you had unlawful presence in the US, but that 601A waiver does not waive the fact that you had misrepresentation in the past. So what will happen is you will go to your interview having your 601A waiver. The officer is still going to find you inadmissible because of that misrepresentation, which now means you also have to file an I-601 waiver for the misrepresentation. Okay? So the reason I say this is a mistake that people can make is when you get to that interview and that comes up, you're freaking out because you did not know that that was even a possibility, right? You thought, I have my 601A waiver. I am done. I can go to my interview and come back in. What you didn't know is that that misrepresentation is a completely different issue that needs its own waiver and that waiver has its own timeline. And that waiver can only be applied for after you are refused the visa at the interview. Okay? That's the time you can apply for that waiver for the misrepresentation. And if you do not know this before you leave the US and you are not prepared for the time it's going to take for that new waiver to be approved and for the embassy to get the approval and reschedule your interview and do all of that and then approve you, you are going to be so disappointed, right? You are going to be so upset because now you thought you may be away from your family for a month or two. Now it's turning into a year or two. So it's really important that you know your full immigration history. When you're talking to your lawyer, you're telling them the full immigration history so that they can properly advise you on if the 601A waiver is the only waiver you need. And then if you have things like criminal history that involves a criminal conviction that cannot be waived, that is another huge thing. Because if you do your 601A waiver, you go to your interview, they find this issue of a criminal history, and then that conviction cannot be waived, you are now stuck outside of the US because there's no waiver for that conviction and there's nothing you can do to waive it, right? There's nothing you can do to get your visa. So that's why This is one of the mistakes people make that end up not only costing them time, but can end up forcing them to stay outside of the US forever. The third mistake people make is not communicating with USCIS on a timely basis. So you move, you don't update your address with USCIS. You get a request for evidence, you ignore it. You don't follow up with USCIS when they send you a notice. So number one thing to do to fix this is to make sure that every single time you move, as the person applying for this waiver, right? Every single time you move, you need to update your address with USCIS within 10 days of moving. If you are watching this video and you already passed 10 days, go and do the change of address today, okay? Do not wait. But you need to make sure every single time that you move, you are updating your address, because the only way USCIS is going to communicate with you about that waiver is through the mail. They will send you mail. If it goes to your old address because you didn't update your address and you don't respond to the request for evidence, they can deny your case. Okay? So it's really important that every single time you move, you update your address. So that's one of the things you can do to make sure you stay in contact with USCIS. The second thing you can do is make sure that when you get any request for evidence, any notice of intent to deny from USCIS, that you are taking action on those things, right? A request for evidence is just USCIS saying, we received your case. We feel that we're missing these things to better get enough information to approve your case, right? Because guess what? If they don't have enough in there to approve your case, you want a request for evidence. You do not want them to deny your case. You want them to send you a request for evidence. And because that's going to tell you what are they looking for in your case to be able to approve it. That's literally why I like a request for evidence. I don't want you to deny the case. I want you to send that client a request for evidence, because it will tell me these are the things that we're looking for in order to be able to approve this case. And if we don't get those things, we're going to deny this case, right? So you should not be afraid of a request for evidence. You should not get it and hide it, right? And forget about it. No, you want to respond. They give you a timeline to respond by, and you need to respond by that deadline. Please do not miss the deadline, because if you miss the deadline, they will deny your case. They will deny your case. So that's another thing you can do is whenever you get any notice from USCIS asking you for more documentation, saying that they intend to deny your case, you are responding to that with more documentation, a statement, whatever is required, you are responding with that. Of course, if you're working with an attorney, they will be telling you exactly what to include in that statement, what to include as evidence, work with you to put together a good response to get your case approved. And then the final thing when it comes to communication is not asking for an expedite, right? I always tell people that you can ask for an expedite. The worst thing that will happen is they say no. That's really the worst that can happen when you ask for an expedite, is they say no. So let's say that the petitioner, the U.S. citizen, spouse, or parent has a serious medical condition. They just need this waiver approved so that you can get your green card, so that you can start supporting financially or whatever it may be. Maybe their medical condition has gotten worse and they need this waiver approved ASAP. You can use that, right, to go ahead and apply for an expedite. Again, worst case scenario, USCIS says no. Best case scenario, they say yes and approve your waiver quickly so that you can get to the visa stage. And then at that visa stage, you can also ask for an expedite. So there's just certain things that you need to do to stay in contact with USCIS and make sure that your case does not get denied while you're waiting, okay? These are 3 things you can do to, 1, make sure that you get communication from USCIS 2, make sure that you're responding timely to USCIS. And then 3, make sure that you're filing for an expedite to speed up your case if you meet the requirements for an expedite. And those are the top 3 mistakes that people make when they are doing their 601A waiver. If you are going through your own 601A journey, or you want to start your journey and you're looking for an attorney to assist you in that, go ahead and schedule a strategy session with me. I can walk you through the process. We can decide if we can work together to make that 601A dreams come true. You can schedule a strategy session with me by going to my website, lilylegal.com, and clicking on Contact Us, where you can pick a date and time that works best for you for us to speak. Right now, my strategy sessions are free, and you get 30 minutes with me to ask me your questions and to see if we can work together. If you are not a computer person, because we are not all computer people, go ahead and call my office at 508-443-1788 to schedule your free strategy session today.